The committee will reconvene. Thank you for being here as a panel. There was a little consternation before you arrived here, so I just want the record to be corrected because Mr. Vollmer, when you testified, you thanked us for our understanding of the limitations of this panel to the committee, and I think that was premature because I don't recognize any right of the agency to lay down limitations as to what members of the SEC have to testify to or not testify to before the Congress of the United States. And unless I'm mistaken, if there's any objections to be made, it would be raised either by the Department of Justice or others. But that notwithstanding, I think we're going to try and be as amenable as we can and civil as we can, just with the idea that I want it clear to the members of this panel, and particularly to you, Mr. Vollmer, that in our discussions and prior preparations for the testimony of this panel, it became obvious to me that there seems to be a dysfunction between the Securities Exchange Commission and this committee of the Congress, in that there seems to be a misunderstanding as to who created who and who is responsible to whom under the Constitution. And I hope we can disabuse ourselves of that misunderstanding. If we can't, we should probably take any legal proceedings necessary to determine that, because I think we're involved in an extremely serious case that requires litigation. And from listening to the testimony of this panel, it appears to me that if these cases remain as they very easily may for years in trial and work, it is the position of the SEC that they can't discuss the matter, can't be called upon to testify on the matter, and are completely removed from participating with the Congress in creating legislation that may be necessary to correct the matters. And although I take great sympathy as a lawyer with the protection of cases to be prosecuted and not to compromise the same, we're obviously dealing here with two different situations. One is what laws have to be made or changed to protect the greater members of the public, and what kind of potential compromises would that cause to a particular case. And in terms of hearing the testimony today of Mr. Markopoulos, I have tentatively come to the conclusion that the Securities and Exchange Commission has been anointed by God to be all righteous. And I hope I can disabuse the members of this panel of that fact, because quite frankly, we're about to decide just in what nature and how the Securities Exchange Commission should continue to exist. And the lack of cooperation shown in the last several weeks, and I think the abuse of authority or the attempt to bring a protective shield over an executive agency or independent agency of this government, is not acceptable. And if that's going to be the process, the easiest thing is to follow Mr. Markopoulos' advice and just do away with the entire regulatory system as it's presently constructed and start anew. And I make that point obvious for a reason. There are several things that have happened in the last several years that should be embarrassing to the SEC. And let me ask that question. Are you embarrassed as members of the higher echelon of the SEC with how the Madoff case has been handled? Or do you feel that embarrassment doesn't come into it and that's unimportant and that you're above all those things? Would anyone like to tell me that?
Let me start. First of all, if we have in any way suggested a self-righteousness to you, I don't feel that. I don't feel it towards the Congress and to the...
Mrs. Richards, so it's understood, and I'll break a confidence. One of the members of this panel is here today, having originally told me he wasn't going to testify because he's exempt. And it precipitated a call myself to the chairman which I rarely make, although I know her very personally and have known all the chairmen for 20 years. But it was so annoying to me that when that individual thought he did not have to testify before a committee of the Congress of the United States, I've made it very clear, either he would be here today or appropriate subpoenas would be issued. And those subpoenas would have been issued to everybody's here today, and quite frankly, we would not have accepted any excuse offered or request for lack of testimony on any facts and have structured a case. And let's see just what kind of protections you would have under the law for not testifying. If we cannot have comedy between two branches of government to handle the people's business, we've got a serious problem. And right now, as this panel is constituted and as I've heard the testimony, I mean, I like oatmeal. And that's about how I classify the testimony I heard today. And now I don't know whether that testimony was written that way and presented that way in order to be a slap at this committee or the chairman himself, but it's not appreciated. We didn't call you up here for us to hear a traveler's guide of the Securities Exchange Commission. We are spending our time and effort, and many of us, to get to the roots of how in the hell a Madoff scandal continues to occur for more than 10 years when a rather credible expert in the field tries to do everything he can year in and year out to alert the appropriate regulator of the federal government that should have handled or looked into that. And now, that's a little therapy on my part. Now, let me hear your response of how good you intend to be.
Mr. Chairman, we are here to help you in your effort. We think this is an important hearing. As to your original question, I think I speak for everyone when I say we hate fraud. We hate the fact that people are victimized by fraud. We wish it never happened. We wish we could get to everyone.
But your job is to prevent fraud, not to hate it.
In the enforcement division, and the division that I know the best, our job is in part to prevent it, but only as a derivative effect of our enforcement actions, because we can only bring actions when a violation of the law has occurred. Now, we want to get to every violation the instant it happens, and we hope that by our actions, there is less fraud to pursue. That is our mission. That's our passion. I've heard today issues about wanting to avoid going after big players. There is nothing that makes a member of my staff happier than bringing a case. The only thing that makes them happier is a big case. And if it's against someone of some notoriety or fame, that makes them happier still. We live for bringing those cases. We hate the fact that people lose money, and we bring hundreds of them every year. And I have to say that sitting here today, it is every law enforcer's worst nightmare to miss something. And yet it is something that we know is going to happen because there's...
Well, how do you explain the fact that you not only missed this, but now that the Congress is attempting to close the loopholes and attend to it, you feel disposed not to cooperate 100% to see that we do that to protect other frauds that may be occurring and going on right now?
Well, let me try to address it, and I understand your frustration, but when we talk about moving forward, what we can do to address it, the first, and to my mind, most important thing we can address it is to hold fraudsters accountable, to bring them to justice, to bring the full force of the law against them. That includes criminal prosecution, civil prosecution, and for example, quite specifically, when you talk about what we did in the past, some of what happened in the past may in and of itself violate federal criminal law. And the ability to pursue those cases to the full extent that we can is what we're here to protect. That does not mean that we should not examine what happened and even examine it theoretically to think what we could do, make assumptions about what the past was, and move from there.
Okay, let me say that justice delayed very often is justice denied. And if we're going to have cooperation and we're going to have an effective enforcement tool of the Securities Exchange Commission, we can't have the culture or mentality that I sense over there. That an examination, an investigation, a process can go on forever. Go on forever. I mean, I have stories that will shrivel your ears with how long enforcement proceedings have just laid around and no action having been taken. And I'm getting the impression that that's the culture now, that there isn't an intent to do something. So one of the things the committee will be considering in some of its legislation is whether or not we can impose a 180-day rule. You know, if we can get criminal prosecutions within 180 days in this country, it seems to me once we charge some corporate activity as being a violation of SEC, let's move along. 180 days, get to a trial, let's get it decided. Something like this, I want to ask a question. How long do you need to resolve the problems that are causing you not to speak or cooperate with this committee? How long do you think these prosecutions are going to take before you can speak up?
I honestly don't know the answer, and there are three things that are going on.
So wait, if that's the case, you don't know the answer, it could be years. Is that correct?
I don't know.
Well, if it is years and you don't intend to say anything, if I listen to how your statement and your counsel structured the statement, there are three things. You can't help if it's a pending criminal investigation. You can't help if the inspector general is doing something. You can't help if it's a ongoing violation. I mean, man,
Well,
if there's a snowstorm in Washington, the SEC can't help. That must be one of the conditions. What I want to find out is how long is it going to take for that to be vitiated, and when can we get together and cooperate in developing legislation that will protect the other 299,999 people other than Madoff?
sure. Let me suggest an approach that may help, because I understand your concerns about how much time it takes to get to specifics. But if you want to try to think about how we can help generally, we can make assumptions. So, for example, you could assume that, to my mind, I like to assume a case where I think the solution is the hardest, because if we find that solution, we will be considerably better off. So when I look at a potential investigation, let me hypothesize. The SEC gets a credible lead. A lead is followed up on to a certain extent, and the investigation is closed without action, as it can happen. Now, when an investigation is closed, it seems to me there are one of two possibilities. Well, maybe four. Either there was nothing to be found and nothing was found, or there was something to be found and it wasn't found. There are probably more, but in those circumstances, if we assume that something could have been found and wasn't, what are the reasons underlying that? And if it's complete and utter corruption, the answer is easy. You get rid of that which is corrupt. If, on the other hand, the answer is that people of goodwill were trying very hard, the answer may be they lack training. And so that's one of the issues that I know has been addressed, or they lack expertise. So what do we do to provide additional expertise to people so that they have the expertise to look further? It could also be that it is a resource issue. That is, you look, you find nothing, you keep looking, you find nothing, and then something else blows up somewhere else that is appearing to be more important at the time. I mean, one of the issues that we are obviously struggling with is if we knew going into something that it was a fraud, a provable fraud with evidence that we could present to a fact finder, it would be easy. When you don't know, that's what you pursue. So I think we would be happy to have that conversation, that dialogue, to make the assumptions to make us better. We try every day to learn from our experience, and so among other things, we're thinking about, as the committee has suggested, what can we do on risk? What can we do for expertise? What can we do to maximize our resources? And those are precisely the kinds of things that we are thinking about even though we can't necessarily share the specifics with the committee.
Thank you, Ms. Thompson. I'm going to call on my ranking member here, who obviously has some additional questions. And I took more than enough time, particularly, I had to have therapy, so you take some.
I thank you. And, Mr. Chairman, when I began my remarks, before I got into my remarks, I commended you on statements that you made earlier today on CNBC with regard to the hearing, with regard to what needed to be done. And it was actually by watching that program, I learned a bit of other information. And then on there, they were talking about an OIG, an Inspector General's report that was just listed on their website either today or yesterday, with regard to a different issue, but still within the SEC. And it's with regarding to uncollected disgorgement, what it's called. And that's not the point of this here, but after seeing that on I guess it's Squawk Box that it was on, I had my staff go and we pulled out a copy of the report because it really didn't go to what we were talking about here, but after going through it, it does in two ways. One, it goes to, on the weed side, or the issue, getting into it, goes to the issue of enforcement and whether there's being enforcement done in general. And as I assume the panel knows, this report raises a number of serious questions. There's about $177 million in uncollected disgorgement. And for those who don't know, and disgorgement just means once you have a case and you find the guy and you get the guy that did the bad thing, then you want to go after them and actually get back those revenues from him, their ill-gotten gains. And I guess as the OIG says, there's these $170 million in uncollected disgorgement. And that would be one issue. But the larger issue is, in going through it, this goes back all the way through 1999, I believe it was, at the very beginning, talking about that the OIG had done similar studies or reviews. And then if you go back at the very end to look to the Inspector General's responses to the management comments, since the OIG gives their opinion, and then management's able to give the response, and then OIG gives a response to that. The very ending of it is, this is them, OIG speaking, notwithstanding this effort, speaking to, in other words, the OIG saying over the last 99, 2001, 2, 3, 4, 5, almost 8 years or 9 years, notwithstanding the efforts of trying to address this situation, the language and the tone of the enforcement's response leaves us unconvinced that enforcement will take the OIG's findings seriously and implement tangible and concrete measures to improve its disgorgement waiver process. I know, Mr. Chairman, we're not going into the whole issue of disgorgement. It just did raise a proverbial red flag that if there's been 7 or 8 years or more of OIG saying, here is our, as an auditor basically, saying, here is our recommendations to make changes, and 8 or 9 years later, there's still those questions. It raises the flag here is that if this as a body comes up with our recommendations saying that we'll just leave it to the SEC to act unilaterally to try to implement changes, that we may very well, as the chairman says, be waiting a long time. So it just raises those questions. I appreciate the fact that I was able to learn that by watching the TV today, quite literally. What I'd like to learn a little bit more, though, is going into some of the issues that the first panel raised. And here's an easy one to start things out. And whoever can either address this right now or address it later on. And I see a lot of gray hair people sitting in front of me, the gentleman that is, which the previous panel was speaking to the issue
There's
of...
gray hair too.
Well, I was never going to go there. The issue was as far as the experience of the people who were conducting in the enforcement side and the examination side. Can you provide us with a response to that as to your number of employees, the salaries of your employees, the years of experience that they have within the department? Now, I notice a number of you spoke to your experience here within the agency, the SEC. First panel, Mr. Markopoulos would probably indicate that he would be suggesting, as others would, that we'd look for experience outside of the agency as well. So if you could provide that to us, a detailed summary of that as prior experience to address that issue. And if anybody would like to, I know you're not going to have that at your fingertips right now, want to address that general allegation, if you will, that the SEC is made up of folks who really come to the table without the adequate practical business experience necessary to get the job, and that they're simply
Sure.
government employees.
I think we would probably all appreciate the opportunity to get specifics to you. Why don't I start, because my division is probably the division that has the greatest characteristic that was complained of. We do have a lot of lawyers in the Division of Enforcement, and that's because we have to prove our cases in court. We ultimately...
Can we just run through? I see my
Sure.
time is almost running
Okay,
through here.
never mind. Let me stop. We have lawyers, accountants, and analysts, as well as market surveillance types, but I'd let the others talk.
Do I have time to
Sure.
supplement that? In the examination program, we are mostly accountants and examiners. There are some lawyers, but the majority of the staff are examiners and accountants. They are CFAs and CPAs. After the Congress adopted pay parity legislation, it gave the SEC the authority to pay our staff at higher salaries that were commensurate with other federal banking regulators. It allowed us to bring in a greater number of staff that had experience, either experience in the industry, in auditing, in compliance. And so in the last, I would expect 4 years, 5 years, our staff has become much more experienced, much more well-rounded than they were in earlier years, where they were more likely to be hired right out of school. So that happened with the change that Congress gave us to pay our people a little bit more. And as a result, we began to keep people longer so they could gain experience in examinations, gain experience in dealing with complex products, complex strategies, and emerging types of compliance risks. So in the last 4 or 5 years, I believe it's a much better situation at the SEC in terms of the caliber and the experience of the examination staff.
With the chairman's permission to ask elaboration on that, the suggestion was, and it's probably a good one, that if you're able to get some people who are in the industry, have worked in the industry most of their lives, and then come into the SEC to start doing enforcement, examination, rulemaking, et cetera, is that a practice to actually go out and seek that individual who has the 20-some-odd years experience, who's about to whatever, to go into this field later on in life?
Let me see if I can answer that question. We understand that it's, look, such people are very valuable, they're very desirable. It's simply hard to recruit them. We absolutely go out of our way to find people with industry experience, and we have such people in our division, trading and markets. More to point, within the division of trading and markets, we have a group of people who are explicitly not lawyers who are collected together to supervise certain risk issues at broker-dealers. These are people with PhD in economics, accounting, statistics, master's degree, exactly the kind of people you would think of you'd want who have quantitative backgrounds to deal with just these kind of issues. And I will point out that some of them teach courses in derivatives on their own time, either before they came to the SEC or as they're at the SEC in the evenings, to just those MBA students that were referred to on the prior panel.
I also just want to add just to supplement that we've in recent years hired former traders in the exam program, which is extremely beneficial to help us look at trading records and unscramble what could be violative trading patterns. And that expertise brought in from the industry has been extremely valuable to us. One of the things we really want to do going forward is to expand that expertise, to hire more quants, to hire more economists, to hire more former traders, so that they can provide a resource, that expertise as a resource to all the staff at the SEC.
I would just close on this, and let's just say that the dilemma that I think that any government regulator is going to have was expressed to me by someone in the industry, and that is that when they deal with you, that if they find somebody, whether he's a young guy out of school or somebody who's been around for a long time and can teach the course or do these other things, and he's a real top-notch guy, no matter what you guys are offering him, in the private market, they are going to offer him a whole lot more. And so we are always going to have that dilemma of trying to get the best and the brightest, because the best and the brightest are going to go where the pay is, and that may not be with the SEC. But I thank you for the latitude to expand.
I am frustrated beyond belief. We're talking to ourselves, and you're pretending to be here. I really don't understand what's going on. Previous witness said that you guys, as an agency, act like you're deaf, dumb, and blind. And I figured you were coming here, you were going to testify before Congress, and don't dare tell anybody you testified before Congress. You're going to be subjected to violation of false advertising lawsuits, all right? You've told us nothing. And I believe that's your intention. I figured you'd leave your blindfolds and your duct tape and your earplugs behind, but you seem to be wearing them today. And instead of telling us anything, you read from the preamble of your mission statement and broke it up into 5 segments. What the heck went on? Your mission, you said, was to protect investors and detect fraud quickly. How'd that work out? What went wrong? It seems to me a private, with all of your investigators and all of your agency and everything that you all described, one guy with a few friends and helpers discovered this thing nearly a decade ago, led you to this pile of dung that is Bernie Madoff, and stuck your nose in it, and you couldn't figure it out. You couldn't find your backside with two hands if the lights were on. Could you explain yourselves? You have single-handedly diffused the American public of any sense of confidence in our financial markets if you are the watchdogs. You have totally and thoroughly failed in your mission. Don't you get it? And now other people are investigating what you should have found out, and you're hiding behind, well, maybe we can't talk because someone else is looking at it. Well, you forfeited your right to investigate by not doing it, certainly not doing it properly or adequately. And now you're trying to tell us that because other people are looking at it, you're not going to tell us what's going on? Like hell you won't. What happened here? That's a question. Do we start with hear no evil, see no evil, or do no evil? Take your pick. I only have 5 minutes. Someone better start.
Let me start with enforcement. As I said, we began an investigation in 2006, and it was closed without action.
Why was it closed without action? What did you investigate? What methodology did you use?
And if in the
Were
interest
you
of...
suspicious when a guy had a one-man accounting firm investigating a $50 billion empire? And you keep saying alleged, alleged. This guy confessed on national television, you might have noticed.
And as I said, our objective is to actually hold him accountable in a court of law, bearing our burden of proof.
You missed your chance.
We have a pending action pending in the Southern District of New York.
You took action after the guy confessed. He turned himself in. Don't give yourself any pat on the back for that.
And, Congressman, every time...
Why didn't you find him is the question.
I understand your question, and we cannot answer as to the specifics. I can talk generally.
You know, if anybody made the case better than Mr. Markopoulos, and I didn't think anybody could, about you people being completely inept, you've made the case better than him.
Well, sir, I am sorry you feel that way, profoundly.
I think I'm reflecting what the American public feels. How are they supposed to have confidence that if somebody goes to you with a complaint, gives it to you on a silver platter, with all of the investigation, with all of the numbers, with all of the data, telling you exactly what he did, how he did it, and why he did it, and how he knows that, and after a period of a half a dozen or 8 years, you don't know anything.
I can only talk about what we do overall.
No, we want to know specifically. I don't want to know what your general purpose in life is. I don't need you to come here to tell me that you hate fraud. Hate when that happens, don't you? But you're supposed to find it out before it happens.
In enforcement, obviously, we can't, and I understand that concern. In enforcement, last year we brought 670 some odd cases. In the past 2 years, we brought 70 cases involving Ponzi schemes. In those 70 cases, close to half of...
Listen, I'm sure you have medals and ribbons and stuff like that, and congratulations on all the good stuff that you've done. I don't want to belittle any of that. But this is huge. How do you miss that? And we know that there are mini Madoffs out there. They're starting to surface. You missed all of those too.
We're bringing...
But this one you were pointed at, and Mr. Markopoulos says he's going to give you another one tomorrow. He's not even giving it to you. He's giving it out to someone else because nobody has confidence in you guys anymore. Maybe the general counsel, Mr. Vollmer. I believe you were the one who thought that your people didn't have to testify here today. I don't know where you got that, but some of us think otherwise. Maybe you could tell us. How did they miss all this?
We're as committed as each of you.
That's not the question. We give you credit for being committed.
Perhaps you could let me answer.
Perhaps you can try to answer.
And what we're asking.
No, we're asking. You have to tell us things. You're forgetting what this procedure is. You're not coming here to ask. We're asking you. How did you screw up?
Inspector General's process work. It's a process Congress set up to identify the facts that we all need to make these judgments. Let's let the system work that Congress created. There will be some recommendations. There will be time for this committee to look at the facts and to think of the recommendations themselves.
Tell that to
And
people who've lost their whole lives that they have time.
Proceed in this matter.
People don't have
Now, the
time. We
other
need
thing
you to
that
tell us
matters
something instead of
is
lecturing us,
that there
Mr. Vollmer.
are law enforcement proceedings going on. There are personal rights at stake. There's the integrity of the
We
investigation.
wouldn't be in this mess if you people did your
That's why
job.
we've asked the committee
No, we're
bear
asking
with
you. We are
these
asking you.
investigations to allow them to proceed.
Could you cite whatever authority you're citing and have cited?
I'd be delighted. I'd be happy to do that. I'd be happy to talk with
Because you have a right
your-
not to answer our questions under the Constitution's Fifth
lawyers.
Amendment procedure. I'm not a lawyer. I'm
I'd
a
be happy
citizen,
to
though.
talk to your lawyers
I'm a
about it.
frustrated citizen.
Happy to give the references to you or to your lawyer.
I'm listening. Give us the references.
There's a very important opinion from the Attorney General Robert Jackson in 1941, where he explained the need to discharge the constitutional and statutory obligations of the executive branch in connection with law enforcement and civil
Are
litigation.
you citing executive branch immunity, Mr.
And-
Vollmer?
In response to requests for information from the Congress.
Are
and
you
it's a-
citing executive branch immunity, Mr. Vollmer?
There are various protections.
Are you
that-
citing executive branch privilege, Mr. Vollmer?
I would like to let you allow me to answer your question.
It's a yes or no question, sir. Either you are or you are not.
No, it is not. There are a variety of reasons and privileges and protections. One of them is executive branch protections. There's a deliberative process protection. They stem from the same desires that you have, and we're asking that you allow those processes to work.
We are out of patience, and the question, obviously, is a yes or no question. Either you're citing executive privilege immunity, or you're not doing that.
I've just explained there are
You know, if you're
varieties,
citing your Fifth
that's-
Amendment privilege, you don't make a speech.
and that's one of them, was the executive
You are,
privilege.
was that a yes? You're citing
I
executive
said
privilege
in
immunity?
part, it is, yes.
I'm sorry?
I said, yes, it is in part.
Have you inquired of the Justice Department or someone else that they have analyzed that position for this hearing today? And they've found that the Securities Exchange Commission requested by Congress to discuss a very important pending piece of legislation that's being established to protect hundreds of thousands, perhaps millions of people, that you have a right representing the executive branch, the President of the United States, to stand on that authority? Have you posed that question to the Attorney General, or
No,
then this is on your interpretation?
this is the position of the agency.
And you're the general counsel for the agency. I assume you make the legal determinations for the agency.
No, the commission makes the decisions for the agency.
So this question
After
has been
obtaining
passed
advice
through?
from a variety of sources, and the general counsel's office is one of
So
them.
this has been passed through the new director or chairman of the commission and the members of the commission,
The
and
commission-
they agree and have instructed you to instruct this panel not to respond to the questions of Congress because of executive privilege and maybe other privileges contained in the 1941 Supreme Court case. Is that correct?
The commission supports this position.
That wasn't the chairman's question.
Yeah, the answer to that specific question is no.
The answer is no. So you're acting on your own volition.
No, I didn't say that, no, and I would disagree with that.
You know, most of us speak English, and we're having a hard time getting an answer from you. This was not discussed by the commission, but it's the commission's position. Is that what you just said? Do you divine that?
The commission's approved taking this position.
The commission has voted the position that you will cite executive privilege in not testifying before this committee and answering its questions.
I couldn't say that to you honestly because the specific reasons
Obviously.
weren't discussed and given by the commission. But the basis is that we're
Your
seeking
value to us is
an
useless.
accommodation, and we've
Your
tried
value to
seek
the
an
American people is
accommodation
worthless.
with you.
Your
And
contribution to
we
this
ask that
proceeding
you
is
take
zero.
into account the concerns that have been well settled over many years, and we'd ask you to take those into account.
Our economy is in crisis, Mr. Vollmer. We thought the enemy was Mr. Madoff. I think it's you. You were the shield. You were the protector. And you come here and fumble through make-believe answers that you concoct and attribute it to executive privilege that you've not consulted with the executive branch on. Mr. Chairman, I'm through.
May I just add a second? You were all in the room when we had a prior witness. If I remember correctly, his testimony was that FINRA was corrupt and the SEC was incompetent. Don't you all want to defend against that, or do you all accept that?
Of course not.
Okay, who's our next one?
Mr. Chairman, on behalf of FINRA, we take great issue with the representation that we as an organization are corrupt. And
Are you going to break your? Are you asserting the same executive authority
I'm not, Mr.
privilege?
I'm not.
Oh, so you're willing to break any rights or privileges you have in order to speak? I just want to make sure we.
FINRA is not involved in the investigation. It's therefore a little bit less complicated for FINRA, but I'm here to answer any question you need answered.
Very good. Mr. Royce, we're going to give you a shot to see if you can get any responses.
Well, in order to try to do that, maybe what we could do is go back to Mr. Markopoulos' testimony, and maybe we can try to get an answer to some of the points that he raised. Specifically, one was what he described as the over-lawyering at the SEC. His argument was that it was the inability for some of the regulators to even comprehend the complicated investment strategies that he presented them. Is there a concurrence that perhaps that was indeed the problem, or can anybody speak to that?
Well, I don't know if Eric wanted to start. I'll start from the
Why don't you start, because this would be enforcement, right?
Okay.
And
From-
you're the
yes.
director for the Division of Enforcement, and I think
I was-
that's the big question mark here. Was he right in that assertion? And then we can go to the next
Sure.
point he raised, okay?
I think without speaking specifically about whether he was right or not, let's talk about the issue of expertise. And I think that's a fair and important issue to discuss. As I said earlier, the Enforcement Division is largely lawyers because our expertise is trying and winning cases. We have to comply with court rules. We have to meet burdens of proof. And that's traditionally a lawyer job. Within enforcement, we have lots of accountants who help us, lots of market specialists and investigators to help us on the core mission of the specific cases. Ours is a pretty micro job. Did this person commit a fraud? Can I prove it kind of question. Now,
Right, but the complexity of the fraud is the problem.
Yes,
And you know, you have a few people that had maybe 25 years' experience
well,
as portfolio managers, but unfortunately, they were on his side. In this debate. They got shut out by the lawyers, apparently.
well,
He had his allies in the SEC, but
again,
obviously,
Again, let me not talk about the
Right.
specifics, but talk
Right.
about the expertise that we do have available to us within the agency. And lots of them are represented to my left. We do go to our peers in the Division of Investment Management. We go to Trading and Markets, an enormously valuable resource for us when we're dealing with broker-dealer issues. We have our Office of Risk Assessment, which is growing. It's a need we recognized some time ago. We have the Office of the Chief Economist.
Well, let me get to a question real quick
Sure,
then.
of course.
The percentage, maybe you could give me an estimate in your division there of broker-dealers or investment advisors or those who have that experience in the exchanges or rating agencies that also maybe are lawyers, but have that kind of experience
Within the division itself?
that are basically in a position to be key decision makers on these kinds of cases.
Within the division itself, very few, but
Well,
within
I think that was his point, wasn't it?
I understand the point, and I think
Yeah.
the issue of expertise is one that I mentioned earlier we do need to address. We have it in the
Let me,
agency.
because my time's limited,
Of
let me
course.
go to Eric Siri really quick with a question, because, you know, the testimony this morning mentioned the vast difference in fraud cases uncovered from cases initiated by industry tips, and that then was explained against those from audits by regulatory bodies, and you must have been struck as we were by the discordant, by the extreme difference in terms of how many of these came from people in the industry that apparently knew more and discovered more in advance. Somehow the private sector was well aware of the Madoff Ponzi scheme before the SEC. And so, you know, do you believe that that's an accurate assessment? And do you believe the investigative priorities, maybe, of the SEC are properly set, given the outcome that we're not just talking about one case here, he was taking in aggregate the number of cases brought because of whistleblowers, how much more effective that was than the experience of the auditing by the regulatory body?
I did understand that the point that he made, and I too was struck by that point, though in many ways not surprised by it. People on the inside, of course, have knowledge and they have their own motivation for releasing that information. When you're on the outside, of course, it's much more difficult to make those inferences and ferret it out. The division I supervise is a policy division. We do not have examiners. We don't have an enforcement function. So I can't speak, I think, to the heart of what you asked, but I would like to follow up on a point that Linda Thompson made. The questions that you had asked were around expertise, and I think expertise, this event that has happened with Mr. Madoff has caused us to think about the way I think we deploy expertise. Chairman Shapiro, in her opening email to us as a staff, said it's time to think about self-evaluation and that we need to honestly take a look at what we're doing and how we are doing it. And I think we all as staff take that precisely to heart. When it comes to a point like expertise, nothing could be truer, because that doesn't cost more money. That's just a matter of working smarter. And I think we try to do that as best we can. We have resources within the SEC, the Office of Economic Analysis, almost exclusively economists with PhDs. My division, mostly lawyers, but as I said, many other folks, I have a PhD in finance. So I price derivatives for a living at times. So I am comfortable with that. Nonetheless, not all those people are brought to bear on the right problem at the right time. That's clearly something we need to work on, and when we see instructions like we got from Chairman Shapiro, I think it's a clue to all of us to figure it out so that something like this doesn't happen again.
Thank you, Mr. Chairman.
Let's see, Melissa Bean from Illinois. Where did you appear from?
I snuck in on you. Thank you, Mr. Chairman. And thank you all for your testimony here today. I guess I direct my questions either to Ms. Thompson of Enforcement or Lori Richards of Compliance. I'm not sure where this would fall. But clearly, the challenges that people feel we're facing as a nation, where there has been lack of compliance and enforcement, isn't new to the SEC. Congress certainly provided additional funding. We all remember Enron and WorldCom and other situations where there needed to be greater scrutiny than has been provided. I guess my question is, how proactive is, and what level of best practices are in place to ensure that, number one, when people actually make complaints and suggest someone gets looked at, are lower level staffers allowed to just dismiss those without a full investigation? And should that continue, or should things have to be escalated automatically through at least several levels of authority before dropping further inquiry? And where there hasn't been any issues raised, what types of best practices are in place to go out there proactively, in the industry to seek where there may be problems and investigate that, at least on a sampling type of basis?
Why don't I start with the complaint process, and perhaps Ms. Richards can talk about some of the examination process, which is directed at proactively identifying issues. On the complaint process, as we mentioned in our testimony, we literally receive hundreds of thousands of complaints every year, hundreds of thousands. So we can't investigate all of them. We take them all seriously. We try to respond to them. So the process for us is trying to triage them to identify those which have the greatest risk of the greatest harm, as well as the greatest likelihood of being accurate or verifiable. And all of you get all kinds of information, tips, mail too. And the real challenge is you can get something that looks terribly credible with lots of detail and lots of exhibits, and it can be, for whatever reason, not true, not verifiable, etc. You can also get some.
If I can interrupt, only because we're
Of course.
limited time. Given that, and given
Yes.
the constraints of resources, what is the criteria when you get multiple complaints about the same organization year after year? How is it that this doesn't rise to senior level attention?
And let me just back up. So we're not being specific about this particular issue, but complaints get followed up, they get triaged, and they are worked. If someone decides to pursue it, it's not an on-off switch. You look at something, you do some work on it, you consult with your supervisors along the way. You may do a little investigation. If it looks promising, you may do more. How much more you do is a decision that gets made along the way, balanced against what you're finding.
So there's no checks and balances within the SEC
there
to
are
say
checks and
if
balances.
someone has decided, based on the degree of knowledge they've taken to pursue, how big the risk or harm is. Clearly, if we look at the Madoff scenario, it met both of those criteria. What are the checks and balances in place to say that someone else decided that was worth moving past?
Well, I'm struggling with how to answer that because in the specifics. I think
Does that have to happen, or can it just be arbitrarily dismissed by an individual?
it is going to be assessed within an organizational group up through supervisors. So, and I think that's as far as I can go specifically. Now, there are certain kinds of complaints that do have specific procedures. For example, if we get online complaints, there are very specific procedures that are followed in terms of responding, and which ones get picked up for further investigation also involve judgment calls. There are specific procedures with respect to SARs, suspicious activity reports, that we review. We try to, for example, depending on the nature of the complaint, if it's an accounting complaint, we have people with accounting expertise review them, all with an eye towards bringing expertise to those complaints.
So let me interrupt again. So
Of course.
given that obviously this was a really big miss, and this dropped repeatedly, is it a lack of resources or a lack of skill sets among those that are in place that are making these decisions, in your opinion?
What I would like to say, let us not assume.
Well, I'm not assuming, I'm
I
asking.
understand.
So
Right,
which?
right. I would
Which?
not well, first, there's a premise I would like to address first. I would not necessarily assume that a complaint was not addressed. And as I
So the assessment was inaccurate, so is that a skill set issue?
and again, I'm not trying to quibble, because the issue is, if assume there is a complaint with which alleges something, as you say, dramatic and specific. That complaint as a matter of practice would be pursued in an investigative way. Then the question becomes what happens in the investigation, and that depends on what you find by way of evidence.
My time is out, so I'll yield back.
Thank you.
Thank you very much. Mr. Posey wishes to examine for 3 minutes and reserve 2 minutes. Mr. Posey.
Thank you very much, Mr. Chairman. I was watching this on TV, eating my lunch, and it just occurred to me how shocked I would be if somebody dropped into my local police department and said, you know, there's a bank robbery going on down the street. Can y'all do something about it? And they said, yeah, if we get around to it, we will. Or, well, we've done bigger robberies than that before. We're not going to worry about that. It's amazing to hear the stories and the testimony that we've heard today. Truly amazing. A question for Ms. Richards at this point, and then I'd like to reserve some of my time. You stated that you had been recused from the Madoff investigation, and I was just wondering why that was.
Yes, thank you for the question. I'm not participating in the current examinations or investigations due to the fact that a former employee who was under my chain of command married a member of the Madoff family, and I attended the wedding. So the SEC has established a process that would allow the staff to recuse themselves from any current or ongoing investigation or examination so as to ensure that no possible questions are raised about the objectivity or the impartiality of the examination or the inspection. So for those reasons, I'm not participating in the current examinations of the firm.
Follow up, Mr. Chairman? Yes. So you asked to be recused?
Chairman Cox, in December, suggested that the SEC would establish a process for SEC staff to ensure that there were no questions.
I understand it, but you asked to be recused. Is that correct?
Yes. When guidance was provided by our ethics counsel, I then took that guidance and recused myself.
Okay. Do you think, had you not been recused, you could have added anything, any information at all whatsoever? It would be at all pertinent?
Add it to this testimony? To today's hearing, do you mean?
No, to the investigation. I mean, it's a question that begs for an answer. Is it innocuous that you recuse yourself and it would have no effect on it, or do you consider your knowledge and insight and service to be of any value in this?
I'm sorry, sir, I didn't understand your question. There are very senior staff at the SEC, very experienced staff examiners who were working on the examination and on the investigation, so I don't believe that there will be any compromises to the quality of the work.
Thank you. Thank you, Mr. Chairman.
The gentlewoman from New York, Ms. Maloney.
Okay, thank you very much. Mr. Markopoulos, in his testimony earlier, testified that he brought complaints 5 times in writing to the SEC. And these were detailed complaints. It wasn't, I think something's wrong. These were detailed complaints that this is wrong, they're not trading, they're not doing this, here's examples. And it was a very specific complaint, not once, not twice, not 3, but 4, 5 times to the SEC. He said he had the support of some people in the SEC, professionals saying that this needed to be investigated. And how many more times would a whistleblower have to bring complaints to the SEC for them to have investigated the Madoff case?
As I think we've made clear, we did investigate in 2006, and the investigation resulted in no action, no recommendation of enforcement action. And so the issue, I think, to a certain extent, becomes in investigations. With any complaint, our job is to verify the information. So
But one of the things he said was that Madoff wasn't conducting trades. Now, if you went in and just asked for the trade slips or proof that they were doing trades, when whistleblowers were saying they weren't doing trades, then you could have shut them down in 1/2 hour. You could have shut Madoff down in 1/2 hour by just following up on one of his allegations that they were not conducting trades. So did the SEC ever use any tools to confirm that Madoff's trades could be confirmed in market transactions?
And as to the specifics of the investigation, I can't answer. As to what we do when we investigate, we try to confirm if we can. If there's a complaint, we try to confirm the elements of the complaint. Oftentimes a complaint
Well, let me
takes us-
tell you something. I'm not an SEC official. I'm not an attorney, but I have common sense. And if I were sent in to find out whether or not he was trading or not, I would ask, where are your trade slips? Where's the proof that you're trading? It doesn't have to be classified information. I find this absolutely outrageous. And if you won't answer it, I think I'm going to appeal to the chairman to subpoena and find out what you did in this case. He further testified today in a very riveting testimony that in 2001, he offered to go undercover. He offered to risk his life to work with the SEC to prove this fraud. Why was that request turned down?
And without talking about the specifics, let me say that we are a civil law enforcement agency and do not do undercover operations. They are exclusively the province of the criminal authorities, and we don't do them.
He also said, and I quote, and he wrote in his testimony, that Madoff was, and I quote, one of the most powerful men on Wall Street and in a position to easily end our careers or worse, end quote. He told me he was afraid for his life that he was bringing these allegations. He was afraid Madoff would have somebody kill him because he was bringing these allegations. And yet they were brought in a very comprehensive way that would have been easy to prove, and you can't testify as to what tools you used or what results you got on looking at whether or not he was conducting trades. I mean, that's pretty basic. When people say he's not conducting trades, it's a complete lie. That would have been able to be proved within a half hour if you looked at it. But maybe the SEC was afraid of, do you think the personnel were afraid of having their careers ended or worse if they looked at Madoff, as Mr. Markopoulos said?
On that one, without regard to Mr. Madoff, absolutely not. Absolutely not.
Has any employees at the SEC ever gone to work for Madoff?
I don't know the answer to that.
Can you look into that?
I
That'd be
think
easy to check.
I think we can, and I would say that the issue of revolving doors, the ethics rules are very seriously. We take them.
I know we have ethics rules. My question was, have any SEC employees gone to work for Madoff? If
I
we
don't
could
know
get
the
that.
answer, and we will
Now,
find
the
out.
Madoff feeder funds were advertising unbelievably high Sharpe ratios. Can you tell us what a high Sharpe ratio is?
Yes, I can. A Sharpe ratio is the ratio between the expected return on the fund and the risk of the fund. So a high Sharpe ratio means that fund is returning a great deal of return for a unit of risk.
Okay, Mr. Markopoulos testified about the Sharpe ratios advertised by Madoff and his feeder funds. Or do you agree that the Sharpe ratios shown by Madoff's equivalent to a baseball hitter hitting 150 home runs a year? Wouldn't you think that was a warning sign? His ratios were so successful? Wasn't that a warning? No one else could get those numbers.
I've not seen those ratios, so I can't say anything specifically, again, about this case.
Well, maybe that's something the SEC should have looked at.
Time has expired.
Did you look into
The
the Sharpe
chair
ratios?
will next recognize
Okay.
the gentleman from Colorado, Mr. Perlmutter, and request of him, if he would yield me 1 minute, I'll be glad to extend his time by that amount.
Mr. Chairman, I will so yield.
You'll be made whole. I just wanted to follow up on Ms. Maloney's very important question, to which the answer was neither opaque nor vague. It was just avoided. But let me, in as much as you're not going to talk to us about specifics, which is why we invited you, that I ask you a hypothetical question. Hypothetically, if somebody came to you with evidence and a charge that somebody was committing a multi-billion-dollar Ponzi scheme and said that that person was not actually even making trades, would it not be standard operating procedure for you to go and see if he had trade slips?
our investigations would
This is
follow.
a yes/no question.
There is no standard operating procedure other than if we took a complaint seriously, we would try to find out whether the facts were true or not.
If you took a complaint seriously, which obviously you did not, is that what you just told us?
No, sir, that is not what I said.
Then if somebody brought you evidence and made a charge that somebody was committing this type of fraud, hypothetically, would your procedure in investigation, I'm asking you a procedural question now, having nothing to do with Bernie anybody, if somebody brought you this information tomorrow, would it not be reasonable to expect that you would ask to see their trade slips?
I think it would be fair to say those are among the things we would look at. The other thing that I
And,
think it would
and, and, and if you did not, would you consider that malfeasance?
not necessarily depending on
Thank you
what
very
we
much.
saw.
Mr. Perlmutter.
Thanks, Mr. Chair. And I got to say, just as an opening statement, the charges and the vehemence that Mr. Markopoulos directed towards all of you, the only person who had any emotion in her voice in the initial opening statement was Ms. Richards. And I mean, cozy, captive, gullible, go along, get along, stupid, lazy. He couldn't use any more adjectives to describe what he felt about this particular investigation. I mean, we've had, we've heard about all the red flags. I don't want to talk about that. I'd like to know, Mr. Donahue, what a split strike strategy is, if you know.
First, I'd start off by saying that I've only been at the commission for 3 years.
Yeah, but do you
I
know what a
started on
split-
Wall Street in 1975 and had many different positions in Wall Street prior to coming to the SEC.
Do you know what a split strike
My
strategy
understanding
is?
of what a split strike strategy is that one creates a collar. You will buy either stocks or a basket of stocks and sell a call, which limits your upside opportunity, and you would buy a put, which would limit your downside risk.
Had you, in your experience, ever used a split strike strategy?
No, I had not.
Okay, Mr. Luparella, what's your understanding of what a split strike strategy is?
It's similar to Mr. Donahue's.
In your experience, had you ever used a split strike strategy?
I have not.
Okay. Just so you two know, I asked Mr. Kotz and Mr. Harback same questions a month ago. They didn't have any clue what a split strike strategy was. They had never used it, and it's classic Ponzi scheme double talk. Okay? You can call whatever it is, and then there's the, secrecy and all that sort of stuff. Let's drop back here for a second, because I really wanted to give all of you the benefit of the doubt coming into this thing. But, Mr. Donahue, there actually was a guy named James Donahue, in Colorado, with a little company called Hedged Investments, had precisely the same Ponzi scheme in 1992. Only $100 million was stolen, not $50 billion. My question is, when you're training your people, do you talk about it's too good to be true, therefore it's got to be? I mean, what kinds of things do you ask your people to look for so they are sheriffs, they are cops, they stop this stuff from happening? Mr. Donahue.
Well, I'd start off by saying that my division is a policy division. I don't have examiners. I don't. I do ask folks that when they're looking at registration statements and things of that nature, that you look at things that might be abnormal, things that are too good to be true, and that is one of the things that we do ask people to look at. And there is no free lunch, and that's one of the things I do try and impress on folks that are in my division.
Well, let me ask you this.
Can I answer that question, sir?
Yes.
With respect to examiners, it's the field office examination staff that go out and conduct examinations. The risk of Ponzi schemes, the risk of theft is foremost in their minds. So they're examining for compliance with lots of provisions of the federal securities laws, but they're always alert to the possibility of fraud. So one of the things that examiners do is they verify records that are provided to them. They would never, for example, just simply ask, are you in compliance with the law or are you engaged in fraud? That wouldn't be enough for an examiner. They'd want to see backup records. And one of the routine aspects of every routine investment advisory exam is to seek confirmation of the holdings of clients directly with a third-party custodian. It's a very basic audit step, and then the examiners will match that with the records that they see at the advisor.
And that sounds great. Let me ask you the question point blank, and anybody can answer this. and then I'm going to yield the balance of my time to Mr. Arcuri. The coziness, okay? Those sound like very good precautions. Is the SEC too cozy with the industry? Are they captive by this industry, or are they looking out for us, looking out for the taxpayers? Ms. Richards, you answer that.
Absolutely not. Examiners, as I said at the outset, they're taught to pull no punches. They're taught to communicate deficiencies and violations without regard to the type of firm, the influence of the person. They are blind to the type or the nature of the firm that they're examining. They truly have a pull no punches attitude.
All right. I'd like, Mr. Chair, to give my last minute to Mr. Arcuri, if I could. I have one more minute, right? Because I had given a minute. I'd yield that to Mr. Arcuri.
Thank you. I thank the gentleman. Real quickly, Ms. Thompson, how long was the Madoff actions allegedly going on?
And I can't answer that as to the specifics.
Okay.
I can't answer the Ponzi
Just,
scheme. Okay.
The answer is you don't know. Next question is, you talked about credible lead. What do you consider a credible lead?
Whether or not a lead is credible and how we assess it depends on the nature of the
No, I
allegation.
understand. I'm a former
Right, okay.
prosecutor.
It's
What do
not-
you consider a credible lead for the SEC?
It depends on what's in it. It depends on the specificity,
Okay,
and it
do you
depends
look
on
at-
how important,
Thank you.
how big it is.
I got it. Did you look at the person who is giving you the lead?
Absolutely.
Okay. And obviously you weigh the credibility of the person who's presenting the lead, do you not?
Yes.
All right. And you give certain greater credibility to people who you determine to be a credible person and less to someone who you would deem to be non-credible.
Generally speaking, yes,
Okay,
although
so-
I have to say that some people who appear incredible have credible leads.
That's true. Now, when Mr. Markopoulos, thank you, came before you, did you consider that a credible lead?
I can't answer that.
You can't answer that? How
Because-
does that affect your ability to investigate or Mr. Madoff's investigation?
Because that is subject of the Inspector General's investigation, and
Ma'am, I've used that excuse a number of times, and I can't even fathom how this could in some way affect the investigation. All right, let me ask you this.
Sure.
In 2006, when you investigated, did you make a determination of any wrongdoing on Mr. Madoff?
we did not bring an enforcement action, and we did not recommend.
That was not my question.
I
Did you make a
understand,
determination whether or not there was any wrongdoing?
And again, I can't answer the specifics on the underlying investigation, other than to say what is public is that there was no investigation.
Did you make a referral based upon your analysis in 2006?
I can't answer that.
You can't answer whether or not you made a referral?
I cannot. And again, this goes back to whether or not, and it's to protect the criminal prosecution.
I understand.
Okay.
Thank you. I
I'm
understand
sorry.
about a defendant's rights, but you made a referral. You can't answer whether or not you made a referral. Okay. Now, next question is this. Do I have any more time, Mr. Chairman?
I don't know whether we should.
I yield
give you
back
any
the
more
balance of my time. Thank you.
Thank you. With Mr. Posey here, we're going to give him 2 minutes, so maybe he can crack this egg.
Thank you, Mr. Chairman, and I'll yield back a minute or two to him if I have any less. It's just such an incredulous tale, I think, for everybody up here to understand. Maybe y'all don't have that kind of a problem grasping with it, but it's just incredibly unbelievable to the people in this committee to hear these stories. I mean, you know, but besides Mr. Markopoulos, we have the Barron's article, we have the Okrant article, we have Merrill Lynch, Goldman Sachs telling their investors, don't touch this. This is impossible. This has got to be a scam. We have hedge fund managers, money managers, with the absolute minimal amount of due diligence, you know, telling their clients by the thousands, this is a joke. This cannot possibly work, and stay away from this thing. And yet, you know, our enforcement agency is blind to the whole. I mean, it's literally hard for everybody to believe. And you know, the question I have is, did anyone else report to you like Markopoulos did and ask you to look at this, you know, report the bank robbery going on a block over?
And while I can't answer it specifically as to this, I can verify one of the things Mr. Markopoulos talked about, which is a reluctance on the part of people in the industry to bring information to us about their peers or others in the industry. It is a frustration to us that people who, legitimate actors in the securities business who ought to be protecting the legitimacy of their business, sometimes do not come to us sort of with leads about potential problems. So that I can say. I can't talk specifically about this particular situation. And if I could turn to, I think we all understand your frustration. And if we knew going into something that it actually was a fraud, we wouldn't investigate, we'd bring that action. If we had the evidence to bring it, we would bring it. There is nothing, I mean, in a perverse way, there's nothing that makes us happier than bringing those kinds of cases.
Well, I think a lot of that frustration was probably because we can't believe when they reported the bank robbery in process, nobody bothered to look, number one. And since you brought it up, all these insiders that kept their mouth shut that apparently knew something was going on, is there anything in the statutes that would make them culpable in this crime? I mean, if I see somebody being mugged and I'm able to do something about it and I don't, I think I share some guilt with the crime.
I think, sir, you may, at a sort of moral or ethical level, I think legally the issues become whether you participated enough to be responsible as either a cause or an aider or abettor. And we will, in all investigations, cast our net wide and deep.
Well, okay, let's say it wasn't illegal.
Sure.
When you license people, don't they have to have a relatively clean background, be free of what they call moral turpitude? And wouldn't that blemish the license of every licensed person if they knew something that, you know, maybe it's not illegal, but it is a breach of morality, at least held by most people in this country, that would be a view. And I would think anyone that you suspect that knew this was going on and didn't report it, although obviously it would have been acknowledged even if they had, but had they not reported it, I think their licenses should be in jeopardy. Just on the grounds of the moral turpitude-free background you expect them to be when they get licensed.
Let me defer that issue to those who know about who are on the licensing issue. I don't necessarily disagree.
Thank you.
Chairman, you're back to finish his question if you like.
Mr. Donnelly, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I asked the Inspector General when he came, how many red flags are enough red flags that you stop what's going on? And one of the red flags was a $50 billion fund with a one-person accounting firm. Why was that one flag not enough for you to shut this down earlier?
Without regard to the specifics of this particular case.
Okay, let's have a theoretical $50 billion fund with a theoretical one-man accounting
Sure,
firm.
that's where I was headed. We need evidence, and that's what we pursue. And if we have evidence of fraud, we bring those cases.
Well, how early on did you know that there was a one-man accounting firm involved?
I can't answer that question.
Well, you were told that in 2001, if I'm not mistaken.
Sir, I simply can't discuss the specifics of this one.
Right. Then let me ask you the next question, which is there a form for examination when your examiners go in? Things that if you see these, you say, this is a red flag, something has to be done.
Let me defer to Ms. Richards, who is the expert on examination.
Let me ask Ms. Richards.
In the examination context, sir, given the number of registered investment advisors, and I'm assuming your question goes to investment advisors, and the breadth of their activities, we have to take a risk-based approach to deciding both which firms to examine and which issues to examine.
Well, let me ask you this. When you go in, and your examiners go in, and they see a $50 billion firm and one accountant, does that tip them off that there may be a situation here?
Investment advisors are not required to have an audit. So the fact that it was a small auditor or a no-name auditor may or may not present a risk. We would look at other things, however, like how are the assets custodied, what are the performance claims that the advisor is making.
How about you combine the accounting with the fact that they go into cash at the end of every quarter? Does that then start to smell a little differently?
If examiners had examined had selected that firm for examination and had gone in, they would definitely look at the trading in client accounts and look at whether it's consistent with representation.
So in and of itself, those are not red flags to you?
It could be. It certainly could be, depending on what representations the advisor made to the customer.
Do you have a form of examination that here's some absolutely critical things that we will never pass on when we do an exam? 1, 2, 3, 4, 5. These are things when we go in we look for. These are things when we look at each company that the basics we want to see.
Yes, when we conduct a routine examination of an investment advisor, we're looking at such things as, what are their representations they make to clients? Are they living by those disclosures? What are the expenses that they're deducting from client accounts? Are they in some way?
And here's the next, I'm going to give my last minute to Mr. Arcuri after this question, but it's this. Back home in Indiana, there's a fella running a tool and die shop who's looking to put a few bucks back into his mutual fund to try to save for his retirement. Why should he have any confidence that the organizations out there have been thoroughly vetted by you?
Well, with respect to mutual funds, which is your question.
Or hedge funds, or like these security funds who you, the organizations that you have jurisdiction over.
We have examination responsibility over firms that are registered with the SEC.
Right.
So that may not include hedge funds. It does include mutual funds. There is a robust regulatory structure around mutual funds. They are also subject to examination by the SEC, though given our resources, we don't examine every mutual fund firm on a regular basis.
Okay, and then let me say one last thing, and then I'll turn it over to Mr. Arcuri. We had a 78-year-old man, I believe he was from Mr. Ackerman or a friend of Mr. Ackerman's, who came before us, and in 2001 you were contacted by Mr. Markopoulos. He continued to put money in, this gentleman did, into the Madoff funds because he had confidence in the system, in the SEC. He believed in you guys as a gold standard. He has zero now, and they're going to foreclose on his house. Mr. Arcuri?
Thank you, Mr. Donnelly. Ms. Richards, if you were to see an investor continually over, let's say, a 10-year period, consistently make a 10 or 12% return for his investors, would you consider that a red flag?
Yes, sir, I absolutely would. The SEC does not now receive performance information of the type you described.
But if you were to see that, you would consider that possibly a red flag?
Yes.
Okay. My next question is, how about if you saw an investor who was giving 4% of the profit that he would normally receive to the feeder companies? Would you think that might be a red flag?
It would be an unusual situation.
Okay. How about if you saw a company that continually at the end of each period turned their cash into government securities? Would you consider that perhaps a red flag?
We would want to understand why.
Okay. Now, if you had those sort of situations, and then you had someone come in who maybe you consider to be a credible lead, give you information, what would then prevent you from investigating that? Why would you not investigate that situation?
My office has authority to conduct examinations, routine and cause, of registered investment advisors. So the first threshold is it a firm that's registered with the SEC?
But if you were to see those situations, wouldn't it be something, and you would receive what would be a credible lead, wouldn't that be the kind of thing that you would want to look into?
We would, in situations where we receive credible leads, the first step is it a registered advisor? If it is, we send examiners out immediately.
Okay, so
they show their badges without notice. They ask.
But bottom line is you didn't do it. You had all of these situations in this particular case, and nothing was done by the SEC, correct? That's a yes or a no?
So
nothing was done.
This firm registered with the SEC in 2006. Following that, there was no SEC exam of this
So you had the scenarios that I just described, you had a credible lead, and yet nothing was done by the SEC, correct? There was nothing done by the SEC, was there?
I think that's not correct. I've testified about the extent of the regulatory examinations of the firm, and Ms. Thompson.
Well, you just indicated that these things would be possible red flags. Ms. Thompson said that maybe it was a credible lead. You had all of these situations, either somebody wasn't talking to someone or there was no investigation done. I have nothing further. I yield back.
Thank you very much, Mr. Cohen. Ranking Member, Mr. Baucus.
Thank you. Ms. Thompson, in your testimony, you say you can't pursue every tip. And are you characterizing Mr. Markopoulos's dialogue as a tip?
I do characterize it as a lead or a tip, just like others, but
Well, at some point it became much more than a tip or a lead, right? Because Madoff was already under investigation.
I can't talk about it specifically.
Well, no, I'm just saying it was.
But
I'm saying that in a case where someone's already under investigation and someone gives you in 42 different contacts, and I'm talking about meetings, discussions, they gave you a case on a silver platter. He described what was going on to a T. And you got the auditor for Madoff was one person in a storefront on Long Island. This begs for investigation. Would you agree that a case like that, with all that information, should have caused someone already under investigation, someone that had failed to register, that was that begged for investigation?
Without reference to the specifics, the more credible, the more informative a complaint is, the more we're going to investigate. And a complaint or a lead, depending on what, our job is to turn it into evidence. And that's what we'd love to do. When we follow things up, we're looking for evidence. We can take leads that are very unspecific.
No, I'm talking about those where where you know of public knowledge, what was published in the newspaper, what you knew from his operation because you had investigated it. You knew that he had failed to comply for years with the law. Was there any penalty for that? Was he sanctioned or was he penalized for that? Was there a heightened, when someone has violated the law for years, in billion-dollar transactions, billions of dollars, is there any punishment or heightened investigation, particularly when someone comes to you, a credible source, and gives you documented evidence?
Without reference to the specifics, there are penalties that may be applied to failing to register, for example.
But they were not applied to him?
There is no enforcement action. There's no public enforcement action prior to the action that we brought in December as to Mr.
Well, that's after it all blew up.
Yes, sir. And as I've indicated, unfortunately, and this is one of the great sort of limits of law enforcement, it is always after the fact when we come in. We don't want it to be. We want it to be as close in time to the illegality as possible. I understand.
I've characterized this. He gave you a case on a silver platter, someone you had been investigating for years, someone that had failed to comply with your own rules, and he wasn't even penalized. Let me take another pay for play.
Sure.
In 1997, my now chief of financial services helped compose a letter with 42 pages of documentation on what was happening, or what we didn't know. We had no idea what was alleged to have happened in Jefferson County. Mr. Markopoulos said it was happening all over the country. Municipalities are out billions of dollars from this pay-for-play scheme. We sent that information to the SEC, chapter and verse. I've now determined that there was apparently no follow-up. Is a county commissioner with documented evidence and a congressman writing, is that not credible information? In 2002, over 2 years ago, I wrote again, pointing out that now some of these people have been disclosures in cases in Birmingham that substantiated all this, and I asked for an investigation. Now, I think at a certain point, after meeting with the commissioner himself, with actually calling him and asking him to come to my office, finally, there was some initiation. But It was all in the paper by the time that y'all.
Well, more generally about municipal securities issues. Municipal securities issues are a priority for us. We have a working group focused on it. We have brought several cases over the last years, and it's one of those areas where, unlike broker-dealers, et cetera, there are fewer regulatory speed bumps along the way, so that our tools are predominantly enforcement, and our ability to discover the issues is more limited as a consequence. But I agree it's an important area to pursue.
Yeah, let me just, and I'll close with this. I have requested that you consider disgorgement for these folks, or for the feeder groups in the Madoff came, that they disgorge their profits, that these wrongdoers in the pay-for-play scheme, that they disgorge to the ratepayers and the taxpayers all over America their ill-gotten gains. And I've heard nothing. I've had no response to multiple requests that y'all consider that. I'd ask you to pursue that.
I'm happy to get back to you on that.
Thank you.
Thank you.
Thank you very much, Mr. Baucus. We're ready to close because we have another markup that has to proceed immediately. We have 2 minutes for Ms. Spears.
Thank you, Mr. Chairman. Very quickly.
I'm going to hold you to 2 minutes, too.
All right. I want you each to grade the SEC on how they handled the Madoff case very quickly.
Can't do it.
Why can't you do it?
Because it would inevitably...
You're giving an opinion. Did the SEC do a good job? A, B, C, D, F.
I wish we'd found it earlier.
So would you give the SEC an F?
I would not. I would not grade it.
All right. Let me ask you this. What's the employee salary in the compliance and enforcement section on average? What are they making?
You know, I don't know. It's in the hundreds of something. It's
all right. So they're making $100,000, $150,000. How many?
I can give you more specific information. This is the range of salaries for an examiner in our New York office. So a typical examiner could range from $47,000 a year to as high as $177,000.
All right, $40,000 to $170,000. How many of your employees, what percentage of your employees in those two branches, enforcement and compliance, leave the SEC and go to work for a SEC-regulated entity?
In enforcement, it's very few. Most, if they leave, go to private practicable.
All right. Ms. Richards?
I think fewer people leave the SEC than they used to, but when they do go, they often go to a regulated entity in the compliance
Mr.
area.
Swanson was the lead attorney on this case. He leaves the SEC, marries Mr. Madoff's niece. Did you, for 1 minute, think that maybe you should go back and look at how he handled that case?
Yes, and that's exactly what the Inspector General is investigating, the role of current and former SEC employees and their interactions with the Madoff firm, and whether those interactions in any way impacted the conduct of the regulatory oversight of the firm. That's exactly what the Inspector General is looking at.
Mr. Einhorn complained about Allied. He came to the SEC. The attorney that handled that case, Mr. Braswell, criticized him instead of Allied. Mr. Braswell left the SEC and went to become a lobbyist for Allied. Do you see any kind of pattern here?
I don't know enough to know whether there's a pattern.
Okay, we'll have to close it there. I'm sorry, Ms. Spear. Mr. Maffei, we're going to give you 2 minutes, but ask you to take one.
Yes, I will, Mr. Chairman. Thank you very much. I just have one question. We heard a lot about the general policy for enforcement at the SEC. Ms. Richards talked about the pull no punches attitude, and indeed, I've talked to folks that are very, in the financial services industry that are very afraid of an SEC investigation. But what I want to know, given the apparent miss of the Madoff scheme, is can you give us any data, and this is, I really would like to know, even if you can't do it now, can you provide any data on the size of the companies on which investigatory or enforcement actions have been taken, so that we'll be assured that you're not just picking on the little guys and throwing the big fish back?
I think we can get you that, but among other things, I would point to the auction rate securities cases, which we talked about before this committee not very long ago. I think it was in August, and some of the aiding and abetting cases we brought against the biggest financial institutions in this country for aiding and abetting Enron's fraud: Citi, Merrill, JP Morgan Chase. So, but we can certainly get you.
I would appreciate the specific data.
Can I just add that we inspect firms, small firms and large firms, in much the same way, with the same pull no punches attitude, and those include firms with billions and billions and billions of dollars under management. So all types of firms are subject to inspection.
Yeah, I would, of course, hope that there's the same standard, and then obviously the question continues, why did we miss Madoff? But I know that's a specific case, so I'm not asking you that question. But thank you very much, Mr. Chairman.
Thank you very much, Mr. Posey. 12 words.
Thank you, Mr. Chairman. I haven't seen this much bobbing and weaving since Muhammad Ali did the rope-a-dope.
Mr. Chairman,
Yep.
I would like to acknowledge from Ms. Thompson and Ms. Richards and Ms. Donahue that there has been some very good investigative actions by the SEC, and you have some top-flight professionals over there. And we don't mean, at least I don't mean to convey that there hadn't been some very good work by the SEC.
Thank you very much.
Thank you very much.
The chair notes that some members may have additional questions for today's witnesses, which they wish to submit in writing. Without objection, the record will remain open for 30 days for members to submit written questions to today's participants and to place their responses in the record. Before we adjourn, the following documents and/or written statements will be made part of the record of this hearing. Mr. Marco Polos' communications with the Securities and Exchange Commission. Without objection, is so ordered. Before we adjourn the panel, I just wish to say we're going to inquire into a process or procedure to see whether the limitations placed upon this panel's testimony comport with the law and whether or not we are able to take such action as to overcome those objections. We will be proceeding with that in the immediate future. The panel is dismissed and this hearing is adjourned.
Thank you.
We're going to start a markup, so nobody should be standing still. People should either be A, sitting, or B, walking to a door. Will people please take seats or else leave the room? No. No. All right. I want to open this markup, and I'm going to call up H.R. 787. Excuse me, what do we got all that crowd back there for? Well, there are two doors. Why weren't the... The Financial Services Committee will come to order. We are going to mark up some bills on which we recently had a hearing, and I call up H.R. 787 and ask the clerk to designate it.
H.R. 787, to make improvements in the...
Excuse me, stop. Close that door, please. Either in or out, but close the door. Clerk will continue.
H.R. 787, to make improvements in the Hope for Homeowners...
I ask unanimous consent that the rest of the reading be dispensed with. Without objection, so ordered. Let me say, we have, I think, 3 bills today, one of which has some controversy. I believe the other 2 do not. Therefore, we're going to begin with the one that is controversial so that we can presumably dispose of that. Members can leave, and then we can deal with the non-controversial ones. The floor is now open for amendments on H.R. 787. The gentleman from New Jersey, Mr. Adler.
Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment to H.R. 787, offered by Mr. Adler of New Jersey. Page 4, line 2.
I ask unanimous consent the reading be dispensed with. The gentleman from New Jersey is recognized for 5 minutes.
Thank you, Mr. Chairman. My amendment would cap at $1,000 the payment that loan servicers could receive from the federal government for the purpose of refinancing a loan. When I was reviewing this legislation, I noticed there was not a limit to the amount that a servicer could receive. My amendment is a common-sense change that will put a ceiling on the amount of taxpayer dollars that can be paid to the servicer. My amendment does not mandate that a fee is provided to the servicer. Rather, it just states that if the Hope for Homeowners Board decides to provide a fee to servicers, then it cannot be for more than $1,000. Capping a payment to a servicer for refinancing a loan is not unprecedented. Last year, when Freddie Mac and Fannie Mae launched their streamlined modification program, they included a flat payment of $800 to servicers. In addition, when the FDIC took over IndyMac, they put into practice a streamlined system to modify mortgages. To encourage participation, servicers received a fixed payment of $1,000 for each loan modified through the program. FDIC officials have already modified more than 5,000 troubled mortgages owned by IndyMac. The payment is intended to help cover expenses for each loan modified with the Hope for Homeowners program. It is not intended to be a bribe to the servicer to participate in the program. My constituents, and I believe yours, are outraged by the TARP, with many viewing the first $350 billion to be wasted. Quite frankly, they do not trust Congress or the Treasury Department. They need reassurance that their money will not be abused. My amendment will close off any possibility that an inordinate sum of money could be paid to a loan servicer for refinancing a loan. I yield back the balance of my time.
Is there further conversation? Gentleman from Delaware.
Thank you, Mr. Chairman. I think the gentleman's amendment is a reasonable approach to a difficult problem. But on a related matter, I would simply point out to my colleagues that we should explore ways to incent loan servicers to modify loans. And again, this bill is about refinancing. But modification is another area of great concern, and we will need to address that at some point in this committee. I will be introducing legislation, Mr. Chairman, which will encourage loan servicers to modify troubled loans, yet split any fees a servicer might receive for the modification. In other words, the servicer would receive a payment up front and then a second payment sometime later, perhaps a year later, once a record of repayment is established and the modification is considered as a success. I will do that later, but I believe modification can be a vital step in avoiding...
Will the gentleman yield?
Well, I do yield.
I appreciate it. The gentleman's been very helpful in trying to get us to the point where people who want to do this thing can do it. We will probably be going to the floor with this package next week. If that amendment that the gentleman is talking about, and given the way Jermaine is, a more broadly applicable one would probably be in order, so I'd be glad to work with him. And if he could get that ready, that might be something we could add next week, because I think we all agree that to the extent that we can encourage voluntary efforts here, we should do it. So the staff of the committee will be available to work with the gentleman on that.
Thank you, Mr. Chairman. I appreciate the offer. We'll try to get it done.
Mr. Chairman?
Yes, gentleman from California.
On the amendment,
I'm not opposed to loan servicers being incentivized. And I know that Indy Mac and Sheila Bair included $1,000 payments to loan servicers in the operation that they put together, and I think Fannie and Freddie included some incentives to loan services. But this is what I'd like this committee to consider. As I said a long time ago when I first got into the discussion on these services, that it's a totally unregulated industry that most members don't understand very well. We don't understand these contracts between servicers and the banks and others, and I think we need to look at this comprehensively. I would think that we should not amend this bill today. The language that's in this bill regarding loan servicing allows the board to deal with this issue. I think we should leave it at that because we don't have a definition of modification. We have 10, 15 different things that are referred to by services and others as modifications. Some modifications include the markdown of interest rates, the markdown of principals. Others just take and rearrange the payments and put a lot on the back end. And so I have been talking to a lot of the independent servicers. I've taken a look at the private industry that's sprung up that you'll see advertisements on television about. One is known as the Federal Loan Modification Company. It's a private entity that asks for $3,500 up front, and people think it's part of the government. This entire area is going to have to be looked at. It's going to have to be determined by the members of Congress and public policy what modifications are. And so I would hope we just leave this alone for today, not amend it, not go any further than this, and look at a comprehensive approach to dealing with an unregulated industry that we don't really have a handle on. I yield back the balance of my time.
Is there further debate?
Mr. Chairman.
Texas.
I just would ask the gentleman from New Jersey, I want to make sure that I understand what the $1,000 limitation is. Is that that would be the fee that the servicer would charge? In other words, if it was a complicated transaction and they needed to get outside counsel to do document preparation or something like that, would that be included in the $1,000, or would they be able to? You see what I'm saying? Is there may be title work or something needs to be done?
The gentleman, as I understand, it's not what the servicer might charge somebody else, but the argument has been that there should be some federal payment to the servicers. Okay, this would only apply to that, not to the general services charges to third parties.
No, I'm say that again, Mr. Chairman.
This applies to what the federal government would pay the servicer. You said what the servicer could charge. The servicer might charge parties. This doesn't restrict that.
I understand that, but I was wondering if they were putting any kind of limitations on what would be included in that. Is this a flat fee, or that the federal government would pay up to, or?
Well, the general deal, it's now permissive. It would be a maximum for each loan, $1,000 per loan. They could pay less. So it's, and this is in the federal payment up at the discretion of the board.
And I think that's the question I'm trying to get at is are we kind of, in other words, is there any incentive to do this for less? Or are we just kind of setting the price?
The general deal, actually, it's now previously been done for nothing. I mean, we're setting the precedent of saying we're going to pay them. And the gentleman Delaware, I think, correctly said we would pay more. There was some concern that, for each loan that there might be, they are, after all, getting paid. The services do get paid by the people who have hired them to service. So then it's a question of people's judgment.
And so I guess the question is, so the person that has the loan, the person that may be getting their loan reworked could also be subject to an assessment by the, and then we're going to give them $1,000.
Well, nothing in here would restrict that, whatever the law is.
I know, but I think the question is, are we paying something, this almost becomes, instead of an inducement, it sounds more like an entitlement to me, is that we're saying, by the way, here's another $1,000
Oh, the general, it is not an entitlement. It's if in the judgment of the oversight board or the administrators it was necessary.
Okay, so
And it's a
we're not-
maximum. It's not an automatic
it's not-
fee.
Okay, I'm not sure I totally, agree that that's maybe the way to structure it, but I don't
You
know.
know, what we've been told again by HUD and others is that some of the services, frankly, the animal deal, they weren't in the business of trying to do anything more than collect checks and pay them out. And that if we expect them to start making the more complicated decisions involved in modification, they may need help just being able to handle it, to hire people and to do it. And it would be up to the 1,000. I mean, right now it's open-ended. So what the gentleman's amendment does is to limit it to 1,000 per loan. It is meant to be, to some extent, compensation for expenses. The notion is that the lack of any payment, even for costs incurred, is a disincentive. That's what HUD's advice to us was.
But it looks like to me it's more in the interest of the person holding the note to pay, or to encourage that person to rework that than the federal government putting extra booty in the...
But if the gentleman deals, this amendment, he's got the wrong objection here. This amendment limits authority to pay that's already in the bill.
But
is that, or does this add the payment authority? Let me double check.
Okay.
Yeah, this is a cap on authority that's already in there.
It's a cap on the authority that's already, so they already had, in the previous bill we had,
Yeah.
and it was unlimited.
This is a cap on that authority.
Okay. I think the gentleman, I take my time back and I yield to the gentleman. Did you have any other comments that you wanted?
This doesn't limit the amount of money that a servicer can pay to counsel to get good counsel. It does limit the amount of exposure the federal government has on each one of these loan remodifications. That's the goal, to make sure that we're not paying an unlimited amount of money to try to rev up the program that I think needs some help. So I think this is a common sense way to limit the federal government's taxpayers' exposure to a loan remodification program.
I thank the gentleman.
It comes on the amendment.
Mr. Chairman.
Gentleman from North Carolina.
I'm just, I guess I'm a little ambivalent about this too, because one of the reasons we're here today is we put so many different restrictions into the original Hope for Homeowners bill, which limited discretion. And the reason we're here is that the program has not worked. And yet this amendment seems to me to micromanage it, or have the prospect of macromanaging it, and run counter to the notion that we are trying to encourage servicers to really be more aggressive in modifying these loans. So that's one side. I guess the other side is, my concern is this, coupled with the safe harbor, could have the adverse effect that people start to go in the opposite direction. But I think I'm more comfortable with the board balancing these than I am trying to micromanage it here in Congress. Maybe the gentleman, Mr. Adler, will want to respond to the concern I'm expressing.
Well, I hear the concern. I don't, frankly, think that the absence of a volume of loans that for the Hope for Homeowners program was specifically because of a fee or lack of fee. We have seen success with the FDIC imposing a $1,000 limit on the refinancing servicing fee in the INEMAC mortgage context, and they've refinanced 5,000 loans successfully. So I think that's a good example of how it's worked and not discouraged sort of loan remodification that we're trying to have achieved here. So I think
but
that example...
if they imposed a maximum and used their discretion to do that, what would make us think that this board wouldn't do exactly the same thing? And why would we want to require a further amendment to the statute if we put in the wrong number that wasn't enough money to encourage services to do this? That's the concern I'm expressing.
Well, if the gentleman will yield, I think Congress needs to do a little bit more of that sort of oversight and regulation. I think we've seen experiences of the last number of months that have not been yielding good results for America, and I think this sort of limitation is common sense. It's worked in the context of the IndyMac mortgage refinancings, and I think it can work here as well.
The question is on the amendment. Gentleman from Alabama.
Thank you, Mr. Chairman. Mr. Chairman, I think we do have to choose here between trying to protect the taxpayers and see that this program, at least the costs, are reasonable, and I commend the gentleman.
Question is on the amendment. All those in favor will say aye. Opposed, no. The ayes have it. The amendment is agreed to. The gentlewoman from West Virginia has an amendment.
Yes, sir, I do. Yes, sir, I do. Thank you.
The clerk will designate the amendment.
Amendment to H.R. 787 offered by Mrs.
I ask unanimous consent the amendment be considered as read, and I reserve a point of order against the amendment. The gentlewoman is recognized for 5 minutes.
Yes, thank you, Mr. Chairman, and I understand that we've been working together with you, and I appreciate your indulgence for letting me offer this amendment, which I plan to withdraw, but I wanted to generate some discussion on an issue that I think is going to be before us not only today, but in the next several weeks. You had mentioned your intent to merge the Hope for Homeowners reform legislation with the mortgage cram-down legislation, and I wanted to raise an issue concerning FHA and the Rural Housing Service loans that are guaranteed, and what kind of effect a bankruptcy or mortgage cram-down legislation, what effect it would have on the FHA now and also on future folks who access those loans. As we know, FHA has been going through a transformative time now and is now originating over 1/3 of the mortgages that we see being created right now. And they have a long established and highly successful foreclosure prevention and loan modification programs that only take weeks to implement. And the fear is, through HUD and others, and I share this concern, is that the low-income borrowers who many times are accessing FHA and VA and RHS, to have them be subjected to higher premiums or a more lengthy process because of the bankruptcy cram-down legislation, I think raises a caution flag for me and for those of us who have worked, and you included, and all of us together, to make sure that FHA can meet the demands and be modernized to be able to create and meet the needs of the borrowers for the future, particularly those low income. Yes, sir.
The gentleman would yield. Let me say this. I think it's not germane because we're not going to be doing bankruptcy. The bankruptcy bill will be coming to the floor. At that point, an amendment would then be in order, and it's obviously not up to me. I would tell the gentleman, I would tell the Rules Committee that I thought it should be made in order, because I think it's a legitimate policy question. I probably wouldn't vote for it, but it's an important policy question. And so I would just say at the point next week, probably, when the bankruptcy bill comes up, I would hope the gentlewoman would offer the amendment to the Rules Committee, and I'll testify in favor of it.
I appreciate that, Mr. Chairman, and realizing that it was not germane, but it's a really important topic, is why I wanted to take a bit of time of the committee's indulgence to open this discussion.
The amendment is withdrawn. I have an amendment at the desk.
Amendment to H.R. 780.
I ask unanimous consent the amendment be considered as read once it is distributed. I recognize myself for 5 minutes to explain what this is about. When we originally considered Hope for Homeowners, the gentleman from Texas, Mr. Hensling, offered some amendments to deal with fraud. The committee agreed to them. Subsequently, we received a critique from HUD under the previous administration, Mr. Montgomery, Mr. Preston, that we had tightened this up too much. I had, frankly, forgotten that I had agreed to these changes, and at one point presented a bill under the TARP bill which eliminated them. The gentleman from Texas properly reminded me that I had agreed to these, and that was part of the process by which they went forward, and it was inappropriate for me to have presented legislation which deleted them. That legislation was the TARP bill, which did not go forward in the Senate, and this would now preempt it. What I then asked him in turn was if our staffs could work together to achieve the purpose, which he correctly pointed out, but in a way that HUD might find less burdensome. What I am offering now is a result of those conversations. It's not everything the gentleman Texas would have wanted. I appreciate, and I would say that, we'd agreed to this. I, again, would stress the impetus to revisit this did come from HUD. And what we try to do in the conversations, and I think his staff and our staff worked very well together, and then the gentleman from Illinois noted one other thing that we kind of omitted that was our fault that we put back in. It's an effort to retain the anti-fraud provisions in a way that, frankly, HUD would still rather not have in, and that's both the old HUD and the new HUD. Some things survive, changes in administration, and the don't bother me attitude is part of it. But I do think this is a reasonable effort to preserve the anti-fraud impetus of the gentleman from Texas in a context that we think is workable, even if HUD might not. And I yield back. Gentleman from Texas, wish to be heard on this.
Thank you, Mr. Chairman. Again, I appreciate you working with us and negotiating in good faith. Again, it's not everything that I would want, but it's certainly an improvement. I appreciate you working with me. I appreciate the ability to work with the gentlelady from Illinois on this provision as well. And again, these provisions were earlier adopted by this committee, so I hope they could be adopted in their present form again.
I thank them. If you would yield, I would just note that I'm very glad that the gentleman from Texas and I were able to collaborate on this, but I would note that since we don't have any windows there, it is reported to me that hell has still not frozen over. Is there any further discussion? If not, the question is on adopting the amendment. All those in favor say aye. Opposed, no. The ayes have it. The amendment is adopted. The gentleman from Texas is recognized to offer an amendment. Gentleman, Mr. Neugebauer.
Mr. Chairman, I have an amendment at the desk.
Amendment to
Clerk will designate the amendment. You got to wait for me to say it.
Okay. Just trying to keep up with you. Amendment to H.R. 787.
I ask unanimous consent that the amendment be considered read. Don't worry, go. That gets easier and easier. The gentleman from Texas is recognized for 5 minutes.
I thank the chairman. And last July, Congress enacted the Hope for Homeowners program. It was a $300 billion foreclosure mitigation initiative, and we were told it would help some 400,000 families remain in their homes. So far, we've heard, and we had testimony yesterday, 25 loans have been modified. While the bill makes changes to the improvement attempt to appeal to more lenders and borrowers, the bill eliminates all the provisions that I felt like were safeguards for the taxpayers. CBO estimates that 40% of the homeowners who refinance under this program will redefault on their loans. Let me repeat that. In other words, if we go in and help these homeowners, 40% of them, almost half of them, are going to redefault on their loans. CBO now estimates that this program will only help refinance about 25,000 mortgages over 4 years, and that will cost $675 million due to losses on loans that will fall to taxpayers. The problem is that's $27,000 per homeowner that their neighbor is going to pick up the tab. In other words, we've got people out there that we know are struggling to make their payments. Some people are having to take in second jobs, and they're struggling to make their house payment, yet their neighbor may be able to go into some kind of a restructuring and get up to $27,000 is some of the numbers that are being kicked around. I don't think the American people are really excited about making their neighbor's mortgage payment and their payment as well. Eliminating this program, and I know there's a number of people on both sides of the aisle here that are interested in making sure that we are not a hindrance, and yet we do things that will help people, American people, stay in their homes. But quite honestly, there's a lot of programs out there right now. We've got the Fed thinking about doing things. We've got the GSEs are doing things. We know that FHA is doing things. We got a lot of programs that we are initiating on this. And here's one that's been on the ground that's not successful. Does that mean we quit trying? No, it doesn't. But what it says about this program is that it didn't work and that it's very costly. And now we've diluted the protections for the taxpayers, And I'm not sure that there are better use of our resources if we are truly interested in helping stimulate housing. And in fact, Republicans have brought forth some solutions on how to do that, to stimulate the housing market, get housing going again, where housing values go up and people aren't underwater. Yesterday we heard from the lady from FHA, and they've helped over 400,000 people with the FHA Secure effort. Maybe there's a way to look at that model. That model seems to be helping more homeowners than this program. The Federal Reserve, as I indicated, they've laid out a plan. We know that President Obama has an idea on how to help homeowners. But every once in a while, Congress doesn't get it right. I think when we don't get it right, then it's up to us to say, you know what, maybe we need to rethink this program. Because quite honestly, when you start spending the kind of levels of money that we're spending, and by the way, we're spending money we do not have, trillions and trillions of dollars that we're going to have to borrow. And somebody else is going to have to pay that back. In fact, what we're in fact doing with some of these programs is we're helping people stay in their homes that maybe necessarily made a bad decision or shouldn't have been there, and we're going to ask our grandchildren and children to pay for those mistakes. And so I know that the chairman has worked very hard, as other members of the committee, on looking at ways to do that, and I look forward to continuing to having that dialogue. But I think what we've seen from testimony and from what the scoring is on this is maybe not the right solution. And so what this does is it says for all those folks that have already entered into the program remains in place, but for moving forward, that the program would cease. And I think it doesn't mean we cease our efforts. It just means this particular program didn't work, and we need to look at other solutions.
I'll recognize myself for 5 minutes to say that if the gentleman's logic had been applied across the board, Hope Now would have ended. In fact, there have been a series of trials and errors here. The administration proposals, FHA Secure and others that he talked about, went through even greater revisions. If you looked at the original version of FHA Secure, if you looked at the original version of Hope Now, and I forget all the names we've all given all these things, they didn't work either. And so the gentleman cites some successes. I think he's cited more success than we've had, but he cites successes that would not have occurred if his logic had been followed, because in all of those cases, the original program model didn't work. And we had some revisions based on experience. In this case, we did have some decisions that came to the Senate that tightened this. What we now have is HUD telling us what it would do to make this work. And he cites the President and the FHA. They are in accord. They believe this is one way for it to work. As to the redefaults, I was struck when the FHA witness, and she was a career witness, not a political one. And I have to say, we've had 2 hearings recently with the FHA. In both cases, they were represented by career people who were very impressive, and I wanted to acknowledge that. They believe with this kind of improvement, it will work, and they will get a much lower default rate. So this is really, I mean, the gentleman's amendment is really kind of an early vote on the whole bill. And
would the gentleman yield?
Yes.
Well, I appreciate, and there have been programs where that in government in every area where there have been, we went back and make improvements. Many of those programs where that was basically the only program in place, and we were trying to make it work. I think the point I'm trying to make to the gentleman is that, one, we've already seen that there's not been market acceptance of this program. It turns out to be very expensive.
Well, I'll take my time back with the gentleman to say that's exactly the point he just made and that I responded to. That is true of all these other programs, that the initial cut in something that we're not clear about hasn't always worked. And what we have done is to revise it, taking into account the empirical evidence that we got. The gentleman's opposed to it philosophically, and I understand that, but this notion that if it's not right the first time or it doesn't work the first time, you abolish it, would have led to the abolition of the programs he cited. I'll yield.
Well, I think what I'm saying is that while this program is not working, it's not the only game in town, and I'm wondering if we would be better served, as I said in my statement, by transferring these resources to some of the other initiatives, you know, and we.
Well, I'll take
we
back
would
my
like
time to say
see
this.
the
First of all,
plan.
again, I want to stress, if we had followed the gentleman's logic, there wouldn't have been any other games in town. The other games are there only because people were willing to do these adjustments. Secondly, no one size fits all. This is aimed at a situation in which you could get right down to principle. It won't apply to everybody. One of the advantages, as Chairman Bernanke has said, is that when you get right down to principle, you're less likely to get redefaults. And I think, yes, they are going to try to have the administration some uniform approaches, but whether you're using Fannie Mae and Freddie Mac or IndyMac, they are somewhat different. And the reason is that people are not all similarly circumstanced. So I think it would be a mistake not to have a variety of programs that could appeal to different people, differently circumstanced. Is there further discussion?
Will the gentleman yield?
Gentleman from Alabama.
Thank you, Mr. Chairman. Mr. Chairman, foreclosures are a problem. I think both sides of the aisle agree with that. They're a problem not only for the borrower, but for the lender. We acknowledge that, but they're also a problem for the neighbor, for the people who live on the street, for the community. Abandoned homes are a tragedy for not only the family, but they're a tremendous problem for law enforcement, for fire, for the communities, and they can lead to blighted areas. For that reason, I think that we in the minority have tried to work very hard in helping create programs which will address foreclosures. But our number one concern in doing this is that over 90% of the American families are not in trouble. They're paying their mortgages on time, or they rent, or they've owned their own house. And we have to focus on approaches that don't penalize them. It's essential fairness that we do everything we can do in crafting these programs to not only allow people to qualify, as the chairman's doing, for these programs, but also protect the taxpayers, the Americans who are paying on time. In fact, we had a witness yesterday who said, I don't make a lot of money. I saved 6 months up. I lost my job, but I've paid on time. I've worked 2 jobs. And I thought she gave some very credible testimony. And I'm hearing that back home. I'm hearing that it's fundamentally unfair to punish those who've played by the rules, discharged their obligations, lived within their means, and acted prudently by forcing them as taxpayers to subsidize those who have got in trouble. Now, you'll recall the freshmen weren't with us, but back in July we passed Hope for Homeowners. It was, I won't say that the proponents were wildly off the mark in what it promised, but they said that it would meet the needs of 400,000 borrowers, and it would protect taxpayers. So they put in taxpayer protections, important taxpayer protections. Well, as a result of these qualifications and taxpayer protections, you had a mere 400 applications and a mere 25 new loans, because the others didn't meet the taxpayer protections. So the chairman is taking a program which failed by virtually every metric, and one of the reasons it failed is because it protected taxpayers. It didn't allow people who couldn't make the new loan qualify. So what he's doing here, in my humble opinion, is he attempts to fix a fundamentally flawed, unfixable program by abandoning key taxpayer safeguards. And that's not just my opinion. The Congressional Budget Office, nonpartisan, projects that if we make these changes, that will still only help 25,000 borrowers at best, far fewer than the 400,000 promised. But even more importantly, according to them, and Mr. Neugebauer said this, if we approve this help, which will probably go to 25,000 homeowners, The cost is $670 million in potential defaults because 40% of the people will default. You know, that's getting up close to $1 billion of taxpayer losses. You know, what's that do to our obligations for Social Security, Medicaid, and Medicare? We're already on a collision course with disaster. And that factors out. And this is not me. This is CBO by taking a
Would the gentleman yield?
to $27,000 per loan. And the lady sitting out there yesterday that said, I made my payments on time, I played by the rules. I don't think that the government ought to spend $27,000 per loan to help these people when there are better programs. Ms. Capito and Mr. Castle, you said you'll cooperate with them. There are programs that are, you said it absolutely right. Well, let me say this and then I'll yield. The gentleman's right. Other programs have gone through a tremendous amount of vetting, adjustments, and didn't work at first. But because we changed them, they're working now and they're protecting the taxpayer. And Ms. Capito, Mr. Castle, we've promised that we want to get a workable program, and we think that some of those programs that have gone through the fire and prove their worth and prove that they better protect the taxpayers are the way to go. And I do appreciate you saying you would work with them.
The gentleman from Ohio was recognized. Well, first, gentleman from Florida. I'm sorry, but I asked the gentleman to give me 30 seconds to yield me. First, I said I would work with Ms. Capito and Mr. Castle. That was in the context of this program. I haven't seen additional programs. I'd be glad to work with alternative programs. I haven't seen those. So yes, that baffles me, that last comment. I said I would work with them in the context of improvements here. Secondly, the gentleman's a little inconsistent about CBO because he talks about the $25,000 and we just got listed as CBO, and he then mocks the $400,000, which came from CBO. So his confidence, the $400,000 figure was not anything that came from any member of this committee or its staff. That was CBO's figure. So the infallibility of CBO is in question, and at the very least, it does not seem to me you can treat them as absolute gospel in the one case and then mock their figure in the other.
Well, Mr. Chairman.
I yield back to it's the gentleman of Ohio's time. The gentleman didn't want to yield to me, so with the gentleman of Ohio's time.
Thank you, Mr. Chairman. Mr. Chairman, the criticism I'm hearing back in Ohio, and certainly what we heard on the foreclosure task force in Ohio, wasn't that the federal government was doing too much and that there were too many programs addressing foreclosures, but that we weren't doing enough. And while I appreciate the gentleman's argument suggesting that those that have been playing by the rules shouldn't suffer, at the same time he does recognize, and I think he made the point himself, that a foreclosure on a street doesn't just affect that family, but it affects the people that are playing by the rules. And so by not helping the family that's going into foreclosure, by not keeping them in that home, you are hurting the same folks that the gentleman's arguing on behalf of. I've got a house two houses down from me on my street, and that impacts my property value. It impacts the property value of the people across the street. So by intervening, whether or not that particular family played by the rules, you're helping their neighbors. So when we talk about 25,000 homes being saved, we're not just talking about 25,000 homes. We're talking about communities. We're talking about neighborhoods, and it's about saving neighborhoods. And the notion that we should be getting rid of programs that might be helping 25,000 homeowners takes us in the wrong direction. We should be doing more to help homeowners, and we should be doing more to help their neighbors. And I support the program.
Would the gentleman yield? Would the gentleman yield? Let me say this. We agree that it's a problem. We agree it affects the community, and we're in agreement with you that we want to try to help. In fact, 788, we're going to support that. I commend the gentleman. That's going to help a lot of homeowners. It's not going to cost the taxpayers anything. The lenders will have to step up to the plate. The investors, those that created the problem. There are programs, Ms. Capito and Mr. Castle are willing to go with some programs that are working much better that may have a cost of $2,000 or $5,000 or $6,000 for taxpayers as opposed to $27,000. So let's work together.
Would the gentleman of Ohio yield to me?
Yes.
He keeps referring to these programs that the gentleman from Delaware and the gentleman from West Virginia has. Would they show them to me? They've apparently showed them to the gentleman from Alabama, but not to me. I don't know what he's talking about in terms of those programs.
We're talking about the programs that you mentioned.
Excuse me, it's not your time. Let's have some rules here. It's my time. The gentleman yelled to me. They don't. Yes, if we're talking about Hope Now and FHA Secure, but nothing that we've been talking about applies to them. My comments to them apply to this program. And yes, we should continue to do these other programs. But he's suggesting that there are things that I haven't seen. I thank the gentleman for yielding.
Mr. Chairman, I'm just simply saying.
Excuse me.
I yield back balance my time.
Gentleman from Delaware.
Thank you, Mr. Chairman. I don't have a plan that you haven't seen, by the way. I have some concerns about the Hope Now program as well from what we have heard, and I think that this is a good discussion because I think it truly needs to be looked at carefully. It obviously is not work particularly well now, and can we revamp it in such a way that it will work well? So I would hope that we all understand that as we go about our votes. But I would like to yield the balance of my time to the gentleman from Texas, Mr. Neugebauer.
I thank the gentleman. The chairman was complimentary of the witnesses yesterday, and I thought that they were professional. I didn't have the answers to all the questions. But I believe one of the quotes from the lady from HUB was, "We really need to scrap this program and start over." And basically, that's what we're saying is that if the number one, the program's not working. Obviously, CBO has a different perspective on the cost per homeowner now. But the most important thing is a lot of the protections for the people that are ultimately going to pick up the tab have gone out of this legislation from the time that we passed it. So here's what we know. We got a program that's going to be expensive. We've got a program that hasn't been effective. And third, we've got a program now that says that, that we're going to disregard the taxpayers' interest and try to see if we can make business pick up. I don't think we ought to try to increase participation in this program at the expense of the taxpayers.
Will the gentleman yield?
Basically, that's basically what we're doing. I would yield to the lady, gentleman. Actually, it's not my time. I'm sorry. I have to yield the time back to the gentleman, Mr. Castle.
Thank you. Does Ms. Beam request time? Yes, I yield to her.
Thank you. I share the concerns of the gentleman from Texas regarding the efficacy of this program. Clearly, it didn't achieve what we had all hoped that it would. But given that we have roughly 8,400 foreclosures per day in this country, I don't think now is the time to limit the options available both to servicers who would like to provide homeowners with options to stay in their homes. These are creditworthy homeowners. That's already in there. That's a taxpayer protection. And while I would have liked to seen slightly stronger protections and fought to include them with you in the original bill that we introduced, we are still maintaining the basic taxpayer protections of creditworthy individuals. And if we look at some of the other programs, like the FDIC program, they have higher foreclosure rates predicted in them because people are still upside down and just stretching payments down against not present values, which they would be able to do in this program. So I just strongly urge members, respectfully agreeing on what we're trying to accomplish, that we do have taxpayer protections. There still is equity sharing in this to protect taxpayers as well and provide more options. I yield back.
Thank you. Reclaiming my time, I yield whatever time I have left to the gentleman from Alabama, Mr. Backus.
Thank you. Let me urge members on both sides, instead of putting taxpayer money in a bucket with holes and pouring taxpayer money in it and letting it run out the holes, why don't we go with these more proven programs where when we put that money in, it stays there and it doesn't result in what the CBO says is a 40% failure rate, and there are programs available.
Will the gentleman yield?
I second. Who's going to drive? Well, that's my point. There are buckets that don't have holes in them, and that's where we ought to go. We're all concerned about foreclosures. Citibank has reworked 400,000 of these mortgages. 400,000. Other programs have been successful because the chairman has put good input and listened in a bipartisan way. We're not saying we don't care. We're not saying we don't want to help. We simply say there are programs where we can do this and safeguard the taxpayer, and that fairness demands that.
The gentleman from Florida, the gentleman yielded me 15 seconds. My colleague from Alabama gives a little bit more credence to Citigroup's claims than I would be prepared to do as to all of those. I thank the gentleman for yielding.
Thank you, Mr. Chairman. Speaking in opposition to the amendment, I think we all understand the massive foreclosure problem we have and the fact that it is not declining, it's accelerating. I think we also understand the balance of protecting taxpayer interests and rights. I also know that what I've heard over and over and over back home is two words: do something. Do something. It's just on so many levels, do something about this foreclosure problem. Now, I would suggest that a menu of different ideas would be welcome. It doesn't have to be just this program. Even if this program picks up 25,000 foreclosures and avoids those people from being thrown out, and I join the gentleman from Ohio in his comment, it's not just 25,000 households that are impacted, but we are talking about hundreds of thousands of people and thousands of neighborhoods that are being impacted by this. I don't agree respectfully with the gentleman's comment about the loss that goes with it. There's always value attached to it. A lot of times we hear these numbers thrown around. We're losing $100 million. Well, there's value in every one of these homes. It may not be what the mortgage is, but there is a value. So I think the numbers are overstated. But more importantly, I think the point that many of us are raising is this one was not working in its present form, this HOPE bill. And the fact that the ideas have now been evolving, and maybe we can make some improvements to them, and maybe it won't be 25,000, maybe it'll be 100,000, and maybe there's some other ideas that are out there, such as the House Resolution 788, which gives encouragement for modification of loans by the servicers, and we passed a bill back in July which encourages lenders to reduce the value, and that didn't work so well. So let's just keep going back and finding the right solutions. But there's no one silver bullet, there's not one solution, and I would respectfully suggest that this is a program that deserves a second chance, and I would just welcome, I think all of us are looking for additional ideas, not necessarily to waste money, but to find ways to keep people in their homes. And for that reason, Mr. Chairman, I would suggest that we defeat this amendment and keep this bill in place.
I would say we have 3 other amendments. Is there further discussion on this one? Gentleman from Texas.
Chairman. Thank you, Mr. Chairman. Clearly, one thing this committee agrees on is that there is a lot of pain in this economy. I'm not sure anybody has a monopoly on pain and on challenge. But when I look at the bill that is before us, you have to ask yourself the question, who are you trying to help? Why are you trying to help them? And at what cost does it come to their fellow citizens if you're going to help them? So I suppose there's a couple of reasons that you would want to go forward with this program. One is kind of the macroeconomic view. Well, housing led us into this economic challenge, and so this is a program that's going to help lead us out. I don't know if CBO got it right, but 25,000 homeowners, and I'm just talking about the macroeconomic view, even if they're in the ballpark, I'm having a hard time believing that this particular program is going to lead us out of this recession. That's point number one. So then you get into maybe the fairness argument. Well, we just need to help these people because they're struggling. Well, there's a universe of people I do want to help. People who are unemployed. We have growing unemployment in the United States. People who have, due to disability or illness, through no fault of their own, can no longer make their mortgage payments. I want to find a way to help those people. But let's not forget, there were a lot of individuals who were not honest about their income, who were not honest about their wealth, who were not honest about their occupancy, who would also be benefit from this program. There were people who made a decision to use their homes as a private ATM when their neighbors did not. There were numerous people who engaged in zero-down programs who essentially were not homeowners, they were speculators who chose to live in their speculative investment. And while Americans all over this country are struggling to pay their own mortgages, should they be forced to help pay their neighbors? Again, there's a basic question of fairness here that I think we have to grapple with. And we need to all be aware there's a universe of people who have already been helped voluntarily. 2.5 million of these mortgages have been renegotiated because by and large it's in the interest of the parties to do it. Now we have legislation before us that I suppose enlarges that universe, but at some cost. According to CBO, $675 million. Is that the right cost? I don't know. But I can tell you this much, as a member of the Budget Committee, if you look at the history of CBO, they are notorious in underestimating the cost ultimately to the taxpayer of these programs. And so I don't have a whole lot of confidence that that is necessarily our final figure. Another figure we need to remember, and although there will be more delinquencies, more foreclosures today in America, roughly 95% of all Americans either own their home outright, they rent, or they are current on their mortgages. And they're the ones who, when they are having their paycheck stressed, their family budget stressed, are being asked to pick up the tab for this program. Now, according to the lady we had from HUD yesterday, she doesn't know what the cost of the program is, but she said there will be a cost to the program. And so I believe that we need to work to help lift all boats. I believe in foreclosure mitigation, but I think there's a better way to do it without a direct taxpayer subsidy. And that ought to be working to preserve jobs that people have today. That ought to be to grow further job opportunities in the future. It ought to be also, as a Republican alternative to economic growth, to offer a tax credit that would help take off some of the surplus that we see in the market today. But I just don't think this is the program that is going to work. I appreciate the sincerity of the chairman to realize something doesn't work. We got to try another way. But we're also on the precipice of the Obama administration coming out with a whole new plan dealing, I believe, with the purchase of toxic assets and these mortgage-backed securities. I just don't believe this is the way to go to place further tax burden on the people who are going to ultimately have to pay this bill. And, Mr. Chairman, I yield back the balance of my time.
The gentleman, Governor, we will return after the votes to complete the legislation. Gentleman, California.
Thank you, Mr. Chairman. I know CBO is talking about 25,000 homeowners. I think if we get this program right, it'll help far more. I'll tell you now, there are more 25,000 people in my district who want to participate in this program if we can get it designed so that the lenders will participate. I would hope that as this legislation moves forward, that we go a little closer to the shared appreciation provisions found in the original program than those found in this bill. The reason for that is we've got tens of millions of mortgages underwater. They add up to $4 trillion of mortgage in excess of value. And most of those homeowners are never going to get any federal help. So we need to show the folks that aren't going to get any help that this is a program that's fair, that those who are getting help have to give up something that those who get no help are able to retain. And a shared appreciation provision allows us to go to our constituents and say, yes, that other person got help, but they gave up a big share of the profit that we all hope to reap when we sell our home. I don't think that shared appreciation will prevent the homeowner from participating in this program. The problem with this program is not a lack of homeowners that want to participate. We all have tens of thousands of people in our district who want to participate in this program, so the fact that those who get to participate have to give up some of the appreciation is not going to deter them from participating. So I hope to work with the chairman as this bill goes forward through the process to strengthen the shared appreciation provisions, both to be more fair and to minimize the ultimate cost to the Treasury. I yield.
There is a vote, Petty. Is there further discussion? If not, the question is on this amendment. Those in favor will say aye. Opposed, no. No. The noes have it. The amendment is not agreed to. The gentleman from Texas. Gentleman requests a recorded vote. Those joining with him will signify. Sufficient number of the recorded vote is ordered. We will recess. We will come back and finish the legislation today.